Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about how to sell your house after your spouse dies in Illinois. The process that you follow to sell your house depends on how your house was titled. You can find out how your house is titled by looking at your deed, and if you can't see on your deed where it states how your house is titled, an attorney with a quick glance will be able to tell you how it's titled. But there's 4 different ways that your house may be titled. If you live there with your spouse. One is joint tenancy with rights of survivorship. Another is owning your house with your spouse as tenants in common. A third is if the house is owned by your spouse in his or her individual name and you're not on title. And the fourth is if the house is held in trust. So we'll talk about each of these 4 ways of titling the house and what the process is for selling it, depending on each of these different ways. So first, let's talk about joint tenancy with rights of survivorship. This is the way that most married couples own their home. And the reason for this is because if you have rights of survivorship, the surviving spouse automatically inherits the deceased spouse's share of the home without having to file any paperwork or go through a probate case. It just automatically happens. The deceased spouse's share passes to the surviving spouse. So in this case, if you own your home as a joint tenant with rights of survivorship with your spouse, when your spouse passes away, there are no extra steps you have to take to sell your home. You can sell it at any time, and the lawyers will handle everything at the closing, and there's no extra complications. A less common way to own the home is as tenants in common. When you own something with someone as tenants in common, when that person passes away, their share won't automatically pass to you. You don't have rights of survivorship. What happens is their share will go to the beneficiaries of their will or their heirs if there is no will. Now, usually if you're that person's spouse, you're the person that's going to inherit that share. But unfortunately, if it's not owned with rights of survivorship or owned in a trust, a probate case will be necessary. A probate case is about a year-long court case, but you can transfer the property before the year is up and sell it before the year is up. But you basically have to open the probate case to either transfer your spouse's share of the property to you and then sell it, or sell it as part of the probate case as the executor, so sell it on behalf of the estate. So that's tenants in common, and that's not a very common way to own your home if you're married. If your spouse owns their home or your home in his or her individual name, and if you're not listed on the title, then it's very similar to tenants in common. Except instead of transferring your spouse's share to you through probate, you have to transfer the whole share of the ownership of the property to you through the probate case, or sell it in probate as the executor. Again, if you own any real estate when you pass away without rights of survivorship or without a trust, a probate case will be necessary to transfer it to the beneficiaries of your will or your heirs. And this is true even if your spouse is the heir or beneficiary of the will. Finally, if you have done any estate planning, your home is probably owned in a revocable living trust. If your home is owned in trust, then similar to owning it as joint tenants with rights of survivorship, the house will probably pass to you automatically, and you'll be able to sell it automatically without having to go through a probate case. The purpose of a trust is to avoid probate, because if you have your home owned in trust and you have most of your other assets in trust, a probate case won't be necessary. And even if a probate case is necessary, as long as your home is owned in trust, the house won't have to pass through probate. Instead, the terms of the trust will dictate what happens to the house. Now, usually, if married couples have a revocable living trust as part of their estate plan, what will happen is, rather than being initially joint trustees and joint beneficiaries of the trust, the surviving spouse will become the sole trustee and sole beneficiary. This means that he or she can basically do whatever he or she wants with the home, including sell it. So again, like joint tenancy with rights of survivorship, if your house is owned in a revocable living trust and you are the sole beneficiary and trustee of the trust after your spouse passes away, there are no additional steps you need to take to sell your home. You can sell it at any time, and you don't have to go through a probate case or file anything. It gets a little bit more complicated if you are not the sole beneficiary of the trust or the trustee of the trust, according to the terms of the trust when your spouse passes away. If both of these mantles don't pass to you, then you need to read the trust or have an attorney read it and see who becomes the trustee of the trust, who the beneficiary is now, and what the trust says needs to happen to the home. In this case, Again, a probate case won't be necessary, but it won't necessarily automatically pass to you, and the terms of the trust will control what happens to the home. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law. We have several geographic locations for your convenience. If you found this helpful, we'd love it if you subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.